Good morning, everyone, and welcome to the Wednesday morning seminar. Today we are joined by Jon Sharp, who is consultant solicitor at Fletcher Day, and he's going to be talking about effective delay analysis, tools and techniques. We are recording the session as always. Jon, if you would like to begin, I will hand over to you.
Thank you very much, Julie. Good morning, ladies and gentlemen. Effective delay analysis, the tools and techniques. We'll have an overview of this, I suppose, is the best way to describe this talk. So without further ado, I shall begin. That's me. Less said about him, the better, really. All the details are on the website. The program. Well, what is the program for? Well, primarily, of course, it's a management tool. We're in effect programming the works that are going to be carried out. Obviously, the monitoring of the progress of those works. And the program is the basis for making or defending a claim. The program has obviously, therefore, a good deal of importance, and it's therefore important that you get it right. Two issues. Is it a contract program? So is, under the terms of the building contract, is a program required under the terms of that contract? If it is, well, what is the implication? Well, there may be terms and conditions in the contract that relate to the program. And if the contract does make express reference to the program, then you need to make sure that there is no conflict between the contract and the program. So you need to look at the contract first to see whether or not a program is required. And if it is required, then you need to set the program to comply with the contractual terms. Otherwise, the program and the contract are going to contradict each other. And shortly, then if the matter goes before the court has to decide whether it's the contract or the program that needs interpretation. That's going to lead to longer court time, and therefore the best thing to do is right at the start is to look at the contract terms. If it does make express reference to the program, make sure the program complies with the terms of the contract. If it isn't a contract program, so the contract itself makes no reference whatsoever to any form of program, what should you be putting into that program? Well, earliest start dates, obviously, need to go in there. Latest finish dates, so what's the latest that the program, sorry, that the works can finish under the terms of the program. Should be reference to provisional sums or stage payments, etc. So what sums are going to be due at the start of the contract, what sums are going to be due halfway through the contract, etc. And also should make reference to access to the work site, so when is that going to be available, etc. Again, it's important that you get those basic provisions in the program. And again, if it isn't a contract program, when should you revise a program? So, if it's a contract program, it will undoubtedly be required to be prepared and be ready at the start of the works. But if it isn't a contract program, you are probably going to have to revise the program as you go along And effectively, if there's, for example, delays to the works, etc., you may well need to look at the program again and revise the program so that it takes into account, I suppose, the reality of the situation. So you've started work on a site, for example, I don't know, and suddenly you find some historic ruins, for example. Now that's going to delay the progress of the works, and the program should be amended to reflect that. If it isn't a contract program, who owns the float? And there's a little chart there which sets out activity 1, activity 2, activity 3, and the floats at the bottom. If it is a contract program, then there will normally be reference in the contract to who actually owns the float. But if it isn't, you need to make a decision about who does own the float. There's another example of activity 1s, activity 2s, and activity 3s with delay there in red. So you can use the program ultimately, though, as an extension of time notice and or to make a claim. So amendments to the program will very often be required if there has been delay in the works, and that's effectively an extension of time notice. But it can also be used, the program, as the basis for making a claim before the courts. So again, it's very important for me to stress that the program has to be accurate. Yes, it may well change over time. So in the example I gave earlier, you start work, you find ruins, there is inevitably going to be a delay. That means that the program needs to be amended to reflect that delay. Now, in the ruins situation, it's likely that all parties will just consent to the delay, whilst archaeologists or whoever come in and look at the ruins and decide whether or not they are worth saving or whatever it is. But there will be other situations whereby it may not be a simple matter of extending time under the program, and that may well lead to disputes between the parties. So getting the program right at the start is important. Decide on who owns the float and make sure the program is updated as the works progress to reflect the reality of the situation. So now, when it comes to assessing delay, under the JCT contract, it's delay to the completion date. So if there is going to be a delay to the anticipated completion date, the program should reflect that. NEC clause 63.3, a delay to the completion date is assessed as the length of time that, due to the compensation event, planned completion is later than planned completion as shown on the accepted program. Going back to the point I made earlier about making sure that the program is accurate and reflects the situation, certainly at the start of the works, it's important that everyone agrees to that program. There's no point having a program of works that nobody likes, nobody agrees to, and thinks is wrong. So some time needs to be taken to make sure that all the parties, certainly at the start of the contract, agree to the program of works, and this is how we're going to carry out the works that are anticipated under the contract. Okay. So remember though, NEC clause 63.3, It's important. A delay to the completion date is assessed as the length of time that, due to the compensation event, planned completion is later than planned completion as shown on the accepted program. So it's important that all parties, at least at the start of the contract, agree to the program of works. Now, global claims. In some circumstances, a contractor might find it difficult to show that a particular breach by his employer caused a particular loss to the contractor. Now, those circumstances are actually more common than you would think. It may be that an employer, for example, hasn't managed to obtain relevant planning permission or has not done something. And although the contractor subsequently suffers loss, so in such a situation, a contractor may try to claim its loss and expense in a single rolled up claim. And this is known as a global claim. So it's almost saying, well, I can't quite put my finger on what the employer did wrong, but I have definitely suffered loss as a result of him not doing several things, or something he should have done but didn't do. But it may be that all these events are very, very minor. There isn't one major thing that the employer didn't do. You could say, and the contractor in those circumstances can say, you didn't do that. Quite clear in the contract, you were supposed to do that. You didn't do it. I've suffered loss as a result. But global claims really come about when there is a series, I suppose, of minor breaches by the employer. Nothing absolutely major, but a series of tiny things that, when added together, have caused the contractor loss, and so the contractor makes a global claim. Excuse me, ladies and gentlemen. Global or total cost claims are terms used to describe a contractor's claim that identifies a number of causes of delay and or disruption and can seek to link them to the contractor's total losses. From this figure, the employer's net payment is deducted and a claim for the balance is made without attributing actual costs to individual events. So as I've said, this is not the case. You wouldn't make a global claim where you can point specifically to an error by the employer which has caused you loss. You would need to look at the contract again, but in the contract there will be obligations set out that the employer has to meet. And it may be in most cases that you can say, right, I've suffered loss because you, the employer, didn't carry out your obligation under clause 3.2 of the contract. Simple and straightforward. However, global claims are there when the employer, I suppose for want of a better description, has not been a very good employer. He's done lots of tiny little things which have caused delay to the program. It may be not responding to correspondence. It may be not attending a site meeting, and that site meeting had to be adjourned to another day. And this happens on 6 or 7 occasions. All tiny things, but these all together will cause the contractor loss. So it's important for the contractor to keep good records of what actually happened. It's not so bad, and it's not as difficult if the employer has breached a major term of the contract. That's relatively straightforward. You didn't do that, and there will be evidence to show that you didn't do it, therefore I've suffered loss. And some of them will be blatantly obvious that the contractor was going to suffer loss because the employer didn't do something fundamental. But it's the little niggling things, as I said, not attending a site meeting, the site meeting has been delayed by, etc. So it's important that you keep an accurate record of the employer's behaviour during a contractual period, so that ultimately, at the end of the day, you may be able to make a global claim because you can point to your notes and say, right, you did over the course of this contract X, Y, Z, and yes, okay, it perhaps wasn't something you were obliged to do under the contract, but by not doing it, you have effectively caused me delay, and therefore I am going to make a global claim against you in relation to all of these tiny breaches of your duties as an employer. The major issue with global claims is that normally for a contractor to succeed with a claim for loss and expense, he must show a causal link between the sums claimed and each individual event that has caused the loss. As I've said before, in some cases it will be patently obvious that an employer who had duties and obligations under the contract didn't do what it was supposed to do. It's easy to point to that breach, and there is a direct then causal link between the breach that the employer committed and the contractor's loss. But it's these minor, tiny, continual little breaches by the employer which add up to cause the contractor loss. So in a global claim, the contractor does not or cannot demonstrate a direct link between the loss incurred and the individual events. It's because they're very tiny, hence the need for the contractor to keep notes. Now, when you're making a global claim in this way, employers often argue that the burden of proof is reversed because it is them and not the contractor who has to undertake a detailed analysis of the events and quantum to show why the global approach is not justified. Employers then go on to argue that this amounts to them doing the contractor's job for it. In a case called Walter Lilly and Company Limited against Mr. McKay and DWW Developments Limited, Mr. Justice Aikenhead at paragraph 485 set out his view that Walter Lilly's claim was not, on a proper basis, a global or total cost claim, despite both parties apparently assuming initially that it would be regarded by such as the court. His reasons were as follows. WLC's final pleadings did identify a comprehensible case in relation to delay. WLC's case for extended preliminaries and profit and overhead was related solely to the periods of delay for which it asserted that it was entitled to extensions of time. The subcontractor claims were largely, though not wholly, it appears from the judgment, largely based on extension delay until the sums actually paid, if not yet paid, due to the relevant subcontractor. It's important to remember as well that claims by contractors for delay or disruption must be proved as a matter of fact. Hence, again, my reference to the contractor keeping good and accurate records of the progress of works on the site And those records should, of course, highlight any delay, especially if it's been caused by the employer. So the contractor has to demonstrate on the balance of probabilities that events occurred which entitled it to loss and expense. Those events cause delay and disruption, and such delay or disruption caused it to incur loss and or expense. Now, you have to prove that there's no point in just, say, assume there has been a delay. You still have to show that you've actually suffered loss as a result of that delay. There may be delays where you, in fact, have not suffered any loss at all. So there's three fundamentals to making an effective claim. The event, you must show what events occurred which entitled the contractor to loss and expense. You must show that those events caused delay and or disruption. And then go on to show that delay or disruption caused the contractor to incur loss and or expense. You need all three. If you're missing one, then it may be that your claim will fail. So it's those three things you have to show. Any contractual restrictions must be complied with. Contractors should be aware of any contractual restrictions on global claims. So it may be that in the contract, it expressly forbids making global claims. Now, if it does, it's unlikely that any global claim is going to succeed. A contract wouldn't be able to exclude a contractor from making a claim where an employer has quite obviously and patently not completed his obligations under the contract. That probably cannot be excluded. And I can well see an application to the court say they've tried to exclude me making any claims, they can't do that. But they can exclude global claims. If there are no such restrictions in the contract, then the contractor simply has to prove his global claim case on a balance of probabilities again. Now, it may be that in the contract, they don't exclude global claims, but they say you can only make a global claim if you do the following. And it may set out 6 or 7 requirements before a global claim can be made. So if your contract contains a contractual restriction, then you must comply with all of those conditions. Otherwise, claims will be barred. And the courts will look at the contract and will interpret it accordingly. If the both parties agree that global claims cannot be made at all, then you're probably stuck with that. If all the parties agree that global claims can be made, but subject to 6 conditions being satisfied, then you must make sure that all 6 of those conditions are in fact satisfied. Evidence required? Well, there's no set way for contractors to prove the 3 elements of a loss and expense claim. However, there are obviously good starting points, and the keeping of accurate records is clearly one of them. We have, and certainly in my time, there are many circumstances where the contractor can demonstrate that he has lost money and incurred expense, but he hasn't got the evidence to prove it. he hasn't got the evidence that demonstrates why he lost this money. So although it is undoubtedly a nuisance on a busy construction project, accurate records are important. A day-to-day note or diary by the site manager noting significant events during each day is very good evidence. However, if that's not available, it is open to a contractor to prove its entitlement with whatever evidence it feels will satisfy the tribunal, the test again being on the balance of probabilities, and of course that can include witness statements. But ideally what you want to be able to do is, yes, of course, have witness statements, but have these witness statements attaching to them documentation actually at the time, that reflects what happened at the time. So that could be a diary entry, a day-to-day account of what happened on the site. It could be emails to the employer to say, you still haven't done this, this is now causing us, etc. What you ideally want is witness statements and hard evidence which will assist you in proving your loss and delay claim. So it's the two elements that you ideally need. Evidential difficulties? Well, in Walter Lilly, the court confirmed that there is nothing in principle wrong with a total or global cost claim. However, it pointed out that global claims do present additional evidential difficulties which must be overcome. Namely, that a contractor will have to establish that the loss which it has incurred would not have been incurred in any event. This means that a contractor will need to demonstrate that its accepted tender was sufficiently well priced, that it would have made some net return, and that there were no other matters which actually occurred which were likely to have caused the loss. In response, the employer is likely to attempt to raise issues or adduce evidence that suggests that the accepted tender was so low that the loss would have incurred in any event. The fact that one or a series of events or factors, either unpleaded or which are the contractor's risk, caused or contributed to the global loss does not necessarily mean that the claimant contractor can recover nothing. It depends on the impact of the events in question. Again, I keep repeating this, but it is important. Accurate record keeping is essential, especially where an employer has perhaps not actually breached a contractual term, but the normal behavior of a reasonable employer, this particular employer, hasn't done that. I said, delaying site meetings, not getting information to the contractor promptly when asked. Perhaps not contractual obligations, but nevertheless, added together, they have all caused delay. And a reasonable employer would have done those things more quickly. But proving that is difficult, and therefore accurate record keeping in terms of being able to demonstrate that these small, perhaps, as I've said, not strictly contractual obligations, but taken in the round and added together, have all effectively caused the contractor some delay. Actual loss, there is no need for the court to go down the global cost route, but the actual costs attributable to individual loss events can be readily or practically determined. A contractor who seeks to pursue a global claim where he could otherwise seek to prove his loss in another way will not be debarred from pursuing his claim, but it may be that the tribunal is more sceptical about the global cost claim if the contractor could have instead proved the direct links but chose not to. Now, it's difficult to understand why a contractor, if there had been fundamental breaches of contractual obligations, wouldn't simply rely on those breaches. To my mind, that would be the obvious thing to do. But there may be circumstances where a global claim is a preferred route rather than relying on individual breaches of contract by the employer. In my opinion, I would always look to the contract and see if there were direct breaches of it by the employer, and if they were, attribute or claim for the loss that's directly attributable to that breach of contract. Actual loss, as warned in the second edition of SCL Delay Protocol, a contractor making a global claim must be aware that there is a risk that a global claim will fail entirely if any material part of the global loss can be shown to have been caused by a factor or factors for which the employer bears no responsibility, and it is not possible for the CA adjudicator, judge or arbitrator to assess the value of non-recoverable portion on the available evidence. So, global claims are not easy. They are much more difficult than being able to bring a claim where there has been a breach of contract, which you can point to by the employer, and you can say, as a result of that, that cost us X. Global claims are more difficult. You still have, especially if you're relying on or making your case on the basis that the employer, although perhaps not having a strict contractual obligation, but didn't behave as a reasonable employer should have done, those are much more difficult claims to bring. So, I think in conclusion, two things. Get the program right at the start. Make sure that everyone agrees to that program. That's important. And if the program is referred to in the contract, make sure the program is in accordance with the contractual terms. Secondly, record keeping. It is much easier to bring a claim if you have good, accurate, and contemporaneous records, which can be supported by witness statements. Then you are far more likely to win the day than if you have no records whatsoever. Thank you very much, ladies and gentlemen, this morning, and I'll pass you back to Julie. Hello, Julie.
Hello, John. Yes, I am still here. Thank you very much for that presentation. Just to confirm, we don't have an evening seminar tonight, but we do have one tomorrow. That is Mohammed Hack with the latest in his changes in construction contracts, the valuation and other implications. So that's at 6 o'clock. If you'd like to sign up for that, please email us on seminars@fletcherday.co.uk. John, we won't be seeing until the following week, where we have another one of his construction insurance case law roundups. So we look forward to seeing him then. All of our online seminars are available to book on the website. And we also send out a newsletter monthly with details of upcoming events, interesting articles, etc. So if you'd like to join the distribution list for that, please email seminars@fletcherday.co.uk and I'll happily do that for you. Okay, John, thank you very much. Without any further ado, we will end the session. Everyone have a great day. It looks like the weather's improving all over, so hopefully no more rain today. Speak to you all soon. Thank you.